The courtroom. A stage where freedom, reputation, and sometimes even life itself hang in the balance. At the center of this battle are two forces: the prosecution and the defense. Each side armed with evidence, arguments, and strategy. But in the end, one question rules them all: whose evidence will the judge or jury believe? Let's break it down. The role of the prosecution. In every criminal case, the prosecution carries the heaviest burden. They must prove beyond reasonable doubt that the accused is guilty. This means their evidence must be convincing enough to remove uncertainty from the minds of the judge or jury. Their weapons, eyewitness testimony, forensic science like DNA and fingerprints, police reports and investigations, digital evidence such as phone records, messages, or surveillance footage. But here's the catch. While the prosecution seems powerful, their evidence isn't bulletproof. Witnesses can lie, forensics can be mishandled, technology can fail, even police officers can make mistakes. The defense enters the battle. Now, here comes the defense. Their mission is not to prove absolute innocence but to challenge the story told by the prosecution. If they can show gaps, contradictions, or even small uncertainties, they've done their job. Their tools? Alibis proving the accused was elsewhere. Cross-examinations that expose lies or confusion in witness accounts. Expert witnesses who challenge forensic results. Alternative explanations that point to someone else. The defense doesn't need to erase every doubt. They just need to create enough to make conviction impossible. A battle of examples. Imagine the prosecution says, "We found the accused's fingerprints on the murder weapon." The defense could respond, "Fingerprints don't tell us when they were left. The accused could have touched that object weeks before the crime." The prosecution insists, "We have an eyewitness who saw the suspect leaving the scene." The defense replies, "But the crime happened at night, and the witness was standing 50 feet away. Can we really call that reliable?" Suddenly, what seemed like clear evidence isn't so clear anymore. Famous cases that show the power of defense evidence. Take the O.J. Simpson trial in the 1990s. The prosecution had mountains of evidence: DNA, blood samples, and even a motive. But the defense team attacked every weak point, questioning how evidence was collected, stored, and tested. They turned the spotlight on police misconduct and raised doubts about the reliability of forensic science. The result? Despite strong evidence, Simpson walked free. Why? Because the jury was left with reasonable doubt. Another case, the Central Park 5. The prosecution relied heavily on confessions, but the defense argued those confessions were coerced. Years later, DNA evidence proved the young men were innocent, and their wrongful convictions were overturned. Here, the failure to properly weigh defense evidence led to a tragic miscarriage of justice. The burden of proof. This is the heart of the battle. The prosecution must prove guilt. The defense doesn't have to prove innocence. All they need is to raise enough doubt. That's why sometimes, even when it feels like the truth is obvious, the verdict goes the other way. In the courtroom, truth matters, but proof matters more. Who really wins? The prosecution wins if their case is airtight, their witnesses credible, their science solid, and their story free of contradictions. The defense wins if they can crack holes in the prosecution's case, expose even small errors, and convince the court that doubt exists. At the end of the day, the courtroom isn't about who tells the best story. It's about who tells the story that can withstand the toughest challenges. Final thought. Defense evidence versus prosecution evidence is not just about facts. It's about credibility, reliability, and persuasion. Sometimes the side with more evidence loses. Sometimes the side with less evidence but sharper strategy wins. In the fight for justice, the winner isn't always the one who knows the truth. It's the one who can prove it. So, defense evidence versus prosecution, who wins? The answer is simple. The side that convinces the court that their version is the closest to undeniable proof.